Thank you, sir. Let me first quote from a reply of Minister of State, Ministry of Corporate Affairs on 1st April 2025 to a question in the Lok Sabha. I quote the reply only. To facilitate expeditious resolution process under IBC 2016, etc., the government has made 6 amendments to the IBC and 122 amendments in its regulation since inception, unquote. So 9 सालों में 6 अमेंडमेंट एक्ट लाया गया और 122 अमेंडमेंट रेगुलेशन में लाया गया. Hence, which clearly proves that the IBC was brought in a hurried manner to make exit route for the defaulting companies from liabilities and defaults in banks, real estate, and other sectors. Let us see what happened after bringing so many amendments. Sir, as of September 2025, out of approximately 8,659 cases, 8,659 cases admitted by the NCLT, 3,865 cases have been resolved. And as per the pendency rate, according to experts, it will take 10 years if this pendency is to be cleared off. Now, sir, average haircut. Haircut has been mentioned. Creditors have faced an average haircut of approximately 67% to 70% on their admitted claims. This means creditors, including banks, typically recover only 30 to 33% of the debt owed to them. आदरणीय राधारमन जी बोल रहे थे कि वो एनपीए कैसे घट गया. वो हेयर कट के बाद जो बचा, जो क्लेम मिला किसी को, वो लिक्विडेशन के बाद, तो वो हिसाब वो दे रहे थे, ठीक दे रहे थे कि 107% या 110%, लेकिन वो आफ्टर द हेयर कट, एंड हेयर कट रेट इज 67 to 70%. In some cases, it reached as high as 81 to 83%. This is the scenario, sir. Now, while precise real-time totals specifically for nationalized banks vary, estimates suggest that banks overall, nationalized bank, overall have foregone roughly 8 lakh crore through haircuts alone since the IBC's inception. Therefore, you can understand how the NPA has been reduced and banks are making profit, it is claimed, rightly claimed, because of this. Then across all successful resolution plans, forget about the banks, I am talking about successful resolution plans in entirety. Till late 2025, creditors realized approximately 3.99 trillion rupees against admitted claims worth roughly 12.31 trillion rupees. So, admitted claims was 12.31 trillion and the realized amount was only 3.99 trillion. Sir, the failure of purpose and haircuts, this bill fails to curb massive haircuts for creditors, which is a tool to reap assets rather than truly resolve them. Other than this, infrastructure bottlenecks, strict timelines, that is 40-day admission, are unachievable, as NCLT and NCAT are severely hindered by vacancies and backlogs, making the amendments impractical. I am not going clause by clause because of the paucity of the time. The new creditor-initiated insolvency resolution process, CIRP, allows selected financial institutions to initiate insolvency without judicial oversight, which could be misused, fuel litigation, and trigger insolvencies prematurely based solely on default rather than viability. This violates Article 14 of the Constitution, inasmuch as they have made a distinction between two sets of claimants. Sir, the bill grants the central government sweeping powers to frame rules for complex areas like cross-border insolvency and group insolvency. Cross-border insolvency and group insolvency. This constitutes excessive delegation of essential legislative functions to the executive branch, which is absolutely unconstitutional as it lacks clear guiding principle within the primary law. This is a law point that I am raising before this august House. Then the bill allows these executive rules to modify or adopt existing provisions of the IBC or the Companies Act, which bypasses parliamentary scrutiny of major policy shifts. This is absolutely unconstitutional. The executive cannot overrun or act above the parliament. Without the scrutiny of parliament, the regulations will be passed, the guidelines will be passed, the directions will be passed by the executive. Never heard, sir. Now, I am coming to another point. The bill introduces a lower value test for dissenting financial creditors. ये COC में जो है, उसमें अगर कोई dissenting creditor रहता है, group of dissenting creditors or single dissenting creditor, whatever, meaning they would receive the lower of the two amounts, what they would get in liquidation under Section 53 or what they would get if the resolution plan's distribution pool were divided hypothetically. So a group of creditors will get higher than the other group of creditors in another case of discrimination. Sir, now I would like to refer a recent observation by the Honorable Chief Justice of India regarding IBC. Quote, unfortunately, the IBC platform is now being misused like anything. You get the company's all assets undervalued, then you indulge in a kind of auction, which is also a completely pre-planned game. Somebody from the family or the close friends comes and buys it. Unquote. This is the crux of the thing. This is why this bill was introduced in 2016, and so many amendments have been preferred by the government within 9 years to help the crony capitalists and the defaulting corporates. Therefore, in my considered opinion, sir, the bill focuses on procedural speed but lacks stronger enforcement of mechanism under Section 66. They never go for that implementation of Section 66 because that is very stringent. It has kept alive to punish the defaulting companies. Section 66 meant for punishing the defaulting companies. It has not been implemented. The companies who defrauded the creditors and or plundered public money and after siphoning funds have knocked the door of NCLT under IBC as an exit route, and it is high time, according to me, it is high time that this IBC in the present form should be repealed and a comprehensive legislation be brought, removing the contentious sections as mentioned, and to revive the claims of the genuine claimants in a manner so that so much of haircuts they are not subjected to. Finally, sir, this bill also have left the government as unsecured creditor. Previously, government was the secured creditors. In all the claim matters in this country, we have seen always the government and the government organizations, public sector undertakings, they are mostly secured creditors. But now, after this amendment, government will be unsecured creditor. And then government money will be plundered. Whose money? Public money. Government means what? Government money means what? Public money. So, with this aim and to achieve this goal, this government has introduced this another amendment, number 7th amendment, to continue the loot which is going on. Thank you, sir.